Good afternoon. I didn't even have the case caption. Thank you. C-335-284, State versus Michael McDonald. Counsel, state your appearance for the record.
Craig Mueller, behalf of Mr. McDonald.
Karen Mishler and Brandon Albright on behalf of the state.
Your Honor, additionally, Mr. John Schaller, a New York attorney, recently passed a Nevada bar, just took his NPR results and is supposed to get him Wednesday or Thursday. He's going to be sitting, with court permission, to be sitting with the counsel table with me, keep track of the paperwork. He's going back to get my tie.
Okay. So let's start first with the motion to, I guess more or less, the motion to exclude the media or the opposition to the admission. Go ahead.
Thank you, Your Honor. I'm not excluding the media.
Video.
Respectfully, Judge, I was around actually as a younger lawyer when we had the debates about letting the cameras in the courtroom. The consensus was that they would cause people to behave or to distort the process. That, for the most part, turned out not to be true. And it has been my experience that generally press interest in cases is generally good for the system and keeps things going forward. Having said that, I've done about 5 or 6 death penalty cases, a couple of very high-profile political cases. I've had cases that have been in the press all the time. I have never breathed a word of objection about having the press in the courtroom. Unfortunately, at this time, I do have to object. This is not, in fact, the press. This group of people is a clique, social, political clique. They run out of family court. They used to be called Judicial Watch, now they're called our Nevada Judges. This purpose of this exercise is not to enlighten or to inform or to do anything to improve the quality of the court. They are here as a bear baiting exercise to pick at and to make sure they've got a video camera if Michael McDonald loses his temper. And when I said that on Friday or before the last court date, I got a 10:30 a.m. text from a mutual acquaintance actually forwarding me their video to make sure that I'm not exaggerating this. This is from a real estate agent who I'm casually acquainted with from the Boy Scouts. She actually sent me the link. Would you like to see what they've posted last time regarding these proceedings?
I suppose it's relevant.
May I approach this?
Yes.
I found this morning when I woke up this morning off my Facebook. Now, you can watch their production.
You left off on July 22nd, 2019, broadcasting live from Department 28 of the Judicial District Court. Senior Judge Kathy Hardcastle presided over the matter because District Judge Ronald Israel was out for a medical procedure. Ms. Hardcastle heard the state's motion to order Mr. McDonald remanded back into custody and granted that motion. During the hearing, issues was stumbled between Mr. McDonald and the half-dozen deputies. It looks like interest in the case has continued to rise. We have 25,300 watch time minutes on YouTube, combined with 26,000 views. And those are just the analytics for YouTube. Specific to Facebook, there are multiple thousand views on both of the hearings, the ones covered on July 10th, 2019 and July 22nd, 2019. There is a trial in this case September 3rd, 2019 at 10:30 a.m. We do intend to appear in broadcast. There is a calendar call on August 26th, which we will send a representative to. It may actually occur that on that date, the trial is moved. So keep an eye out for any updates from us on Facebook and YouTube. It is anticipated that this time District Judge Ronald Israel will be presiding. It looks like Karen Mishler will appear again for the 3rd time, at least as far as we have covered for the state of Nevada, and Craig Mueller, it appears, will be representing Mr. McDonald. Of course, keep an eye on the Facebook page as these little details may update as well. Because this is a formal jury trial, you'll get to see a submission of evidence, the testimony of witnesses, and the jury themselves will be making a determination as to whether or not Mr. McDonald is guilty or not guilty on the 11 felony counts that he's facing.
Thank you. Have you seen this, State?
No, Your Honor.
that, hopefully you could hear it. There wasn't,
Yes.
all it was a face, with that. Go ahead. You wanna say it again? You wanna say it? Go ahead.
I think, I get the gist, Your Honor.
It's on YouTube as what?
YouTube, Facebook, this isn't, and, Your Honor, respectfully, these gentlemen are welcome to stay in the courtroom and report and ask questions. Our defense is not complaining about the press in the courtroom. That's not what the purpose of this is. This is to get sensational videotape. Now, there's not any reason, this is a clique of people that they follow family court, and they are gleefully up here watching Mr. McDonald. This is against the background of this case. You may recall, this is the first time in 30-something year career I've ever seen anybody being charged with falsifying documents in family court, one of which is substantively true, and the other one supposedly on his financial affidavits. So that's it. This is not a man with a criminal record. This is a man who hasn't been allowed to see his kids, and they're going to sit here and poke at him emotionally until he cooks off, and they're going to get it on videotape, and then they're going to gleefully post it. That's not going to add to the proceedings. Now, in a very narrow fact, this issue presented in this case is, were the documents fraudulent or forgery, or was there an attempt to forge them or not? Now, I previously moved to dismiss this charge on vindictive prosecution. We've heard you give me a fair day in court. I won't relitigate that. But respectfully, Judge, I've never even heard of a family court judge just not taking action themselves and referring it to the state or to the district attorney's office. That's against the extraordinary background of the district attorney's office seeking to intervene into a family court case, which I don't know, I've never even heard of such a thing, or that is procedurally allowed. Fortunately, Judge Henderson ruled that it was not. Now, this is bear baiting. It is not a solemn trial of a vindication of constitutional rights versus the rights of our community. This is nothing more than poking at an emotionally distraught man on a very narrow theory of liability. And I told my colleagues this. In my career, $80,000 embezzlement case, district attorney's office can't get bothered with it, says it's a civil matter. Future Judge David Barker allows a woman with a $325,000 embezzlement case from her boss to get a gross misdemeanor. Now, those are the kind of responses I've seen traditionally done by the district attorney's office, and I'm standing here defending a man on two theories of liability. One, the affidavit that he turned in that the judge said, or the author said was true, but he added a couple words to it for clarification in a case he's litigating by himself is actually a fraud. And secondarily, that his financial affidavit, when he doesn't have a job, is incorrect. Now, this is vindictive prosecution. It is an unusual, at best, theory of criminal liability. The narrow issues that the state's going to have to prevail on are very narrow, and I do not see that the ends of justice are served by having this camera and turning this into a circus.
Two things before I let the state talk. Did you get the opposition filed by, well, I think it was filed by the individual who runs or owns that company?
I saw that the one was filed on the way to court this morning. I've not had a chance to look at it.
Can you tell them to bring me a copy of it? All right. Tell them to have you seen a copy?
The state has, Your Honor.
Okay. You have extra copies? Are you Mr. Falcone?
Yeah, Mr. Falcone here, I have a copy.
Do you have extra copies to give?
No, I just brought one for myself. You can have it.
You can. I've read it. Now give it to Mr. Mueller. Thank you.
Best interest is not, can you give her a pony?
I'm going to ask the question, make sure we're being accurate with what the doctor means. To find out what the facts were. I agree, the record's a mess.
I make a finding that paternity has been established.
He was a potential danger to his children.
We're here for the court's order to show cause. Okay, so that takes care of one motion.
In response, Judge, I'd ask you to
Well, take a
inform-
minute, read it.
I see what his arguments are. This isn't a fact finding. And I want to remember, Judge, the state has changed its theory of criminal liability. We did a preliminary hearing on this case where it was deduced that there's about 7.5 million documents filed every year in Clark County Family Court Division. This is the sole prosecution on a fraudulent document. And even then, it's not arguably not even fraudulent. Now, this is not a fact finding. This is a witch hunt. It's not fact finding. Ask Mr. Falcone how many other family court cases he's televised. Ask how many double homicides or police shootings he's come down here and covered. He's not interested in any of that. That's not a fact finding. This is bear baiting for entertainment and spectacle, nothing less.
Well, at least address the issues that are outlined in the, both the Supreme Court rule and the decision. And I will say, because I read the decision, it's not on point for this case. But the issues, sorry, Steve, can you, the case is either on my desk, I think. Can you?
Look on your desk, Judge.
Or Elsie has it. Solid versus 8th Judicial District Court. Does the state have a position since he's reading that at all?
No, Your Honor, the state has no position on the allowance of cameras and the media in the courtroom in this case.
And the second issue, counsel approach.
We'll be distracted by the cameras in the courtroom. Now, we make no pretense, and the court clearly is well aware of the emotional state of Mr. McDonald. This is a hideously inflamed divorce proceeding. Now, having said that, if this case becomes an emotional circus, justice will not be done. This is a very narrow theory of liability that the state has to establish. I'm deeply skeptical that they can do so. I believe concentrating on the narrow legal issues presented is what we need to do, and not to get involved with all the who shot Johnny that's gone on with this case. This case I've never seen so many procedural irregularities, let alone seen them all in one case. The district attorney tries to intervene in a family law case. I mean, really? district court judge down at family court won't enforce their own orders? Really? We're up here trying to, on a jury trial where we're stacked up on murder cases, we're doing a jury trial on whether a document that is concededly correct in substance, if not procedure, is a forgery, and we're up here deciding whether a guy who wasn't working was found actually indigent. He doesn't have enough money to hire an attorney, so now he's going to be held accountable for documents on that account. Now, that's 4 procedural irregularities, none of which I've ever seen before. Then we had this circus showing up and wanting to film every aspect of it. I don't believe that this is a trial in any sort of proceedings that I've been familiar with. And I've shared with you the other 2 or 3 financial crimes I've done in the last few years. It's inconceivable that the office that couldn't prosecute a $325,000 embezzlement really wants to hang a felony on this guy's, Mr. McDonald's head. Now, I know it's a big organization anymore, and Mr. Left Hand really knows what Mr. Right Hand's doing, but at a certain point, this lapses into vindictive prosecution.
All right, thank you. The case and the Supreme Court rule clearly outline both the, if you will, rights or burdens. Number one is there's a presumption that the courtroom proceedings are open and can be televised. That's exactly what was going on in the Solid case. The findings, if you will, are A, the impact of coverage upon the right of any party to a fair trial. They, both in that case and in this case, we will be picking a jury, and I don't see that the photography, the video, whatever you say, is going to be impacting the jurors. This and your arguments are well taken that this isn't a high-profile trial, and despite the YouTube or Facebook or whatever it was hits, all that means is that it's salacious, the fight, and that's why people looked at it. That's, of course, all too common, but that is not going to, well, we certainly are hopeful that is not going to happen. We will have a calm and organized trial. B, the impact of coverage upon the right of privacy of any party or witness. Mr., how do you say your name?
Alexander Falcone.
Mr. Falcone, one thing, well, certainly one thing you may or may not have been aware of, you are not allowed to take pictures. The camera will not, better not include any of the jury, and you won't be allowed during jury selection to videotape because they're moving around too much and there's too much going on to preclude you. Jurors are coming and going all the time, and unless you are extremely careful, you would be taking pictures of potential jurors, which is not allowed. Second of all, witnesses, unless they give you specific permission, you're not allowed to take their pictures. You can use the sound, that's fine, but you're not allowed to do that. C, the impact of coverage on the safety and the well-being of the party, witnesses, or jurors. As I said, you're not allowed to take pictures of the jurors, the witnesses, or for that matter, Mr. Well, I don't know why I forgot, McDonald. C or D, I don't think the likelihood of the coverage distracting participants, given the fact, as I said, this is not a national news coverage. This is one individual putting it on YouTube and hoping to make money off it. I'm sorry?
We're not monetized.
You don't get money from YouTube?
No, to get monetized, YouTube has to create a partnership. That hasn't occurred.
Okay, so in any event, what about Facebook?
Same thing, Facebook's even harder.
You don't get hits off of that?
There are hits, but there's no payment, there's no checks.
All right, in any event, as I said, there's minimal exposure. The adequacy of the physical facilities, we're fully capable of taking care of that. I don't think any other factor affecting the fair administration of justice. What their motivation is does not concern me. It is, as I said, Mr. Mueller, that's a very small contingent, and the fact that people from potentially all over the country look to see a courtroom, whatever you would call it, certainly Mr. McDonald's failure to cuff up, as they say, I don't think those are grounds to exclude coverage. In addition, I want to point out, because quite frankly, my marshal pointed out, we have 65 or 75 jurors coming in, which, along with the parties and other personnel, puts us at the maximum for, as you can see up there, 84 occupancy. So during jury selection, we are maxed out. If you want to sit there, that's fine. You're welcome to sit in. But as far as videotaping during jury selection, it is both impractical and would impede the progression, because people are coming and going, as I said, when they're deselected, if you will, and you would be hard pressed to avoid filming individuals coming and going constantly.